Every day in the USA, people find themselves in court.
I'm going to call John Miller.
Mr. Miller, please come forward. Raise your right hand. You're going to be sworn in, and then you can come and have a seat in the witness stand.
Do you affirm that the testimony you're about to provide in this matter shall be the truth, the whole truth, and nothing but the truth?
You may begin.
Good afternoon, Mr. Miller. Your name is John Miller, is that correct?
Correct.
You're one of the plaintiffs in this matter.
Yes.
Do you have property that abuts or is near to the Alcium's property in Burnett County, Wisconsin?
Yes.
And are you next door neighbors or is there space between?
There's a fair amount of space.
Okay, but your property lines abut?
Property lines do abut.
And when people drive over this causeway to get to your property, or I'm sorry, to get to the Alcium's property, do they have to drive by your property to get there?
Yes.
Are you up in Burnett County here quite a bit at your cabin or house on this?
Yes.
peninsula? How often would you say you're up here?
I would say once or twice a month.
Is that all year round or is that just in the summer months?
That's year round.
So you've been aware, you haven't testified yet, but you've been aware of the issues out on the peninsula. Is that a fair statement?
Yes.
Okay, what issues do you have with the Alcium's property today?
My biggest issues would be traffic, which can be extremely busy anytime there are renters, and usually they are large groups of renters. The place is advertised as holding 22 or sleeping 22 people. So the traffic can be immense, and not just on arrival and departure, but coming and going 2, 3, 4 times a day. Anyway, a lot of traffic. As far as
Let me stop you there. So go back a little bit. So you have property that abuts the Alciums. Do you also have other property on the peninsula?
we actually own a fair amount of the peninsula, and I have picked up parcels of land over the years, kind of in an effort to keep it quiet and isolate it, and for the most part have been successful.
So are some of those parcels, if you will, that you've picked up built upon or not built upon?
They are not built upon.
Okay, and that's to your point you just made, to keep it quiet.
Yes, sir.
Have you observed ATVs at the Alcium's property?
Yes.
And are those ATVs sometimes brought by renters?
Oh, yes.
Tell me about the ATVs. Do they cause you any concern?
The primary concern is just the noise and the traffic level, the congestion. They're fairly loud.
Have you observed any tree removal from your property?
I have observed trees down, yes.
Did you authorize the tree removal or the cutting of those trees?
No,
Was it clear to you that somebody had cut them?
yes.
So it's not like the wind just blew them over. Somebody actually cut the tree down.
These were sawn.
You've been in court today. Is that true the whole time?
Yes,
So you heard testimony about a tree with an ATV with a chain wrapped around it. Did you hear that testimony?
yes,
Okay, and the testimony I think is that tree it is on your property. Is that correct?
that's correct.
Okay, did you authorize anybody to tie a chain around that tree and try to damage it or make it come down?
No,
Thank you. Yes.
I'm showing you what's been marked as exhibit number 4 for today's hearing. Do you recognize the first page?
I do.
What's on that first page?
This would be the Elysium's cabin.
I'm sorry, the Allsums?
Elysium's, I'm
Okay, I
sorry.
just didn't hear, I'm sorry. Okay, and then just a second ago, you said, he advertises it as though it sleeps 22. You see that in the middle of the page there?
I do.
Okay, now I want to turn your attention to the top left corner of the page. Do you see that date?
You're referring to
Top left corner, in the very, very corner.
2/3/25?
Yeah, yesterday, is that correct?
No, that would be yesterday.
And as you turn the pages to the rest of this exhibit, there's pages 1 and 2 and 3 seem to have writing on it. 4 and 5 do not. Is that accurate?
That is correct.
Okay, and then 6 through 10, that appear to be just a larger of zoomed in copy of the same thing.
I would say a larger picture, a larger copy.
Easier to read. Your Honor, we would offer exhibit, I think it's 4.
4. It is received.
I have no further questions for Mr. Miller.
Mr. Olseams, do you have questions for Mr. Miller?
No questions.
Ms. Olseams, do you have questions?
No questions.
You may step down. Thank you.
Thank you.
Mr. Anderson, do you have any additional witnesses? You can just leave that up there.
Your Honor, if
I have Mr. Donahue
that's what,
on Zoom.
is he still on? Yeah. If he's available,
Oh, man, since I had to mess, can you unplug your computer? Is it unplugged from my system?
Yeah. Yep.
Plug, so. There we go. I can see you now. All right, Mr. Donahue, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Thank you. Mr. Anderson, you may begin.
thank you, Your Honor. Is there any way to be
Oh,
able to see his face?
Oh, yes. Oh, no, yes, we can. I just have to hit a button. I don't know why that is on there.
There we go. Thank you. Mr. Donahue, can you hear me okay?
Yes, sir.
Okay, and can you please state your name for the record? I think we can see it on the screen, but I want to make sure it's right.
Paul Donahue.
Thank you. And sir, do you own real estate in Burnett County?
Yes, sir.
And is that real estate on a peninsula in Burnett County is it Birch Island Lake?
Yes, sir.
Do you share a property boundary with the Alsiums?
Yes, we do.
And I think you said that you've been here all day so far by Zoom. Thank you for doing that. It's my understanding that you've heard everything then. Is that a fair statement?
Yes, I have.
So you've heard some conversation about and questions and answers about a septic system. Did you hear that?
Yes, I have.
Okay. Have you had the occasion to smell foul odors or bad smells? It was previously referred to as a poopy smell.
Yes.
You smelled that, and do you know where it's coming from?
Yes, yes, I do.
And where is it coming from?
It's coming from the Alcium septic tank,
Okay, and how do you know that, sir?
because it's sitting right adjacent to our property line.
Okay. How do you know it's not coming from your septic system?
The wind is coming from the proper direction to waft the odors towards us.
All right. And also, you smelled, well, let me ask you this. How many times are you, say in a year, how many times are you up at your property in Burnett County?
In the summertime, every other weekend. In the winter time, once a month So.
So you smelled the septic's smell, the bad odors a few times over a summer, a couple times over summer, a few times over the years. Give us a frequency.
Several times over the summer, occurring when large groups are present.
There's also been testimony today about traffic on the properties. Are you aware of that?
Yes, sir.
And have you taken any specific action yourself in relation to vehicles or traffic out on the peninsula?
Yes, occasionally we do put a chain up across our driveway so that people are not parking or turning around on it.
Okay. Did you put that chain up across your driveway because you had in fact experienced that happening?
Yes, I have.
Your Honor, I have no further questions for this witness.
All right, thank you, Mr. Olsems. Do you have questions for Mr. Donahue?
Yes. Mr. Donahue, are you a septic systems expert?
No,
Or
I'm
would
not.
you claim to be? Have I ever invited you on my property to look at my septic system?
No, you have not.
Have you ever obtained a report from any septic expert that says that my septic system is failing?
No, I have not.
So are you just guessing that the smell is coming from my property?
No, I'm not.
Well, if you hadn't have an expert that says it's coming from there, how do you know that the odor is definitely coming from my septic system?
I know what a septic tank smells like when it overflows. And I know where it's coming from the direction of the wind.
Have you noticed any puddling of liquids?
No, I have not.
Ms. Olsems, do you have questions?
No questions.
No further questions.
No further questions. All right, thank you, Mr. Donahue. You are now released. You may remain on through the duration of the case if you wish, or you are free to leave.
Thank you, Your Honor.
Your Honor, may I take a 90-second recess to confer with my client?
Actually, let's take 3 minutes. We'll come back at 2:05.
Okay, thank you.
Back on the record, same appearances as previously noted. Mr. Anderson, you still have the ability to present your case. Do you have any further witnesses?
No further witnesses, Your Honor.
You're closing your evidence.
Yes.
Okay, now we are turning over to your side, Mr. and Mrs. Olsems. I don't know, I'm gonna ask Ms. Olsems first, because I'm not sure if you're wishing to give any testimony or provide any testimony here today. That's your choice. I don't know how much you're participating in this case, how much you're actually involved, but that's why I'm asking you first if you are going to, or if you think you are going to provide testimony.
And is this for the damages?
For both,
For both?
yes.
Both meaning damages and contempt, right?
Yes.
Okay, thank you.
I can provide
Want to wait and
some-
see?
for what?
If you want to provide testimony.
Just say wait and
I was
see.
thinking that if you were going to provide testimony, you might take a little less time than Mr. Olsems, but if you feel more comfortable in waiting,
Oh, wait then. Okay,
I'm fine with that too.
Okay.
I just want to make sure that you have the opportunity to testify right now if you want to.
Then I can.
Just
And you
wait
want to
and see.
wait?
fine.
Whatever. Let's just go with Mr. Olsems.
Okay.
Mr. Olsems, please come forward, raise your right hand.
Well, first of all, I'd like to make a motion, Your Honor. The equivalent is if we were in a trial, a directed verdict, I'd like to motion the court to find in favor of the defendants on the contempt hearing. And I have two major reasons for that. The first is a civil injunction, how it differs from a criminal situation is that, for example,
Did you read my decision? Because I explained it all in my decision in order exactly.
Yep. But I'm just pointing out,
Okay.
I just want to, if you let me get through my motion, I'm just basically pointing out to the court that the purpose of a civil injunction is not to penalize past alleged non-performance. The point, that's a criminal matter. That's if the corporate counsel of Burnett County had a problem, which really this is where this should be, in front of the corporate counsel.
No, it
If
doesn't
they-
have to. Do you know Wisconsin state law? And I'm very clear. I'm very to the point in my decision that was filed on October 4th, 2024, exactly answering all of those questions. Okay, all of those things. A property owner under Wisconsin law can go, you know what? County's not doing it because it's the county's discretion if they want to enforce their own zoning ordinances. If they choose
Well, I
not
understand
to,
that.
stop. If they choose not to, a property owner has the right to do that. That is exactly what is occurring here. Exactly what is occurring here.
but-
Exactly.
Okay, but the difference is, again, there has to be a current non-compliance. The purpose of a civil injunction is that you can't say 6 months ago, somebody broke my injunction, so now I'm going to impose a punishment. The purpose of a civil injunction is to compel current compliance. So what that means is, if I was renting the property right now today, if there was somebody in my house and renting it without the permission of the county, then you would have the power to compel me because of that injunction, to remove the renters. But what we're talking about here is simply trying to punish past non-performance. And that's not the purpose of a civil injunction. And what we have here, Mr. Anderson has not proven that there is any current renting going on at the property. So on that basis alone, again, one of the things I want to mention is I went through the same thing in the state of Minnesota.
I know you did, and you went to prison for it.
No, I'm talking about the
The
civil.
other thing? Oh, okay.
I'm talking about the civil part of it. The same thing as the township went through the civil avenue of doing this exact same thing. And the appeals court ruled that it was totally improper, that it's not the purpose of a civil injunction to impose a,
Do you know how many times I have to tell Minnesota attorneys? How many times I have to tell Minnesota attorneys, you can't rely on Minnesota law in Wisconsin?
no, I'm not saying you can, but there also,
You
that
can't.
does influence,
Read Wisconsin law, please. Like, if you're going to be in my state of Wisconsin and my county, Burnett, read my Burnett County ordinances, our local ordinances, and read the state of Wisconsin laws, okay? Because how many attorneys that come from Minnesota? I know, because I'm licensed in Michigan, I'm licensed in Minnesota, and I'm licensed in Wisconsin. So
I
the
understand
laws
that.
are all different.
But I get it, but the common denominator though is applicable to every state, and that is the Constitution. The reason why the appeals court said that you can't do that is because it's unconstitutional and it breaks the rule of equal protection. If an example is, let's say in this case, the county did decide to prosecute somebody for renting their property. Went through the whole process, they were assigned a $300 fine. Okay, now they decide to take this direction and you take that direction and you decide to impose a sanction of $500,000. That's not constitutional. It's not equal protection. We both did the same thing, but you're imposing a completely different punishment. And that's what the appeals court said was, in fact, there's a ton of case law in Minnesota. Again, I'm not saying for
Okay,
Wisconsin.
I'm stopping you right now again. You're done with this directed verdict argument because I've already made my decision and you can't ask for reconsideration. My
I'm
decision,
not.
stop. Now, stop. My decision was October 4th, 2024. If you can't read English, I will read it to you, okay? It is 26 pages long, but I will read every single word to you. You understand? That is my decision. And you could ask for reconsideration, but that time has passed. When we are done with this hearing, which is the contempt hearing, as well as the damages hearing, when we are done with these two hearings, then my dear litigant, Mr. Olsiums, you can ask our great Court of Appeals here in the great, wonderful state of Wisconsin to listen to your arguments that you are arguing right now. You can argue those to them. I've already read your first brief that you've done. Woo, way off course anyway in your Court of Appeals, but you'll probably refile the same thing. But here we go. Okay, we are in the contempt and damages portion, second half of this case. We are
get it.
not here for a directed verdict for you to rechange my mind. The time for reconsideration has passed. 20 days gone. Okay? October 4th, 2024 was my decision. We are here for the contempt and the damages. I'm not reconsidering. I'm not changing my decision. That is what it is. Okay?
Okay, have a second
Directed
argument.
verdict denied.
Wait a minute.
Denied.
I have a second
Are you-
argument. I have a second argument.
What's your second argument?
The second argument is that the local ordinances say 10 days or less. You do not need the permission of the
Denied.
county.
We are for contempt.
Therefore, but Mr. Anderson hasn't proven anything more than 10 days.
Oh, no.
Can
I-
I can help here. I promise.
Well, I know you can help. So can all of my notes
Yeah, yeah.
and all of my things. I listen very well. I take lots of notes. People know that about me. I read. I'm a judge that reads lots of things, every word I read. So 10 days, and you're thinking they didn't prove up to 10 days, and you are
You're-
swearing under oath, you're swearing under oath that in 2024, well, actually from 2023, July 2023 to present, or no, July 2023 to July 2024, you didn't rent more than 10 days.
No, that's
Is
not
that
true.
what you're swearing to? Is that what you're swearing
I'm saying
to?
what the ordinance is a calendar year. It says per calendar year. So 2023's got nothing to do with it.
Okay, then from
It says-
January 1st, 2023.
No, no,
to-
2024.
No, I'm
2024.
going back. I'm going back. From January 1st, 2023 to
That's not what he's
January
alleging.
1st. Can you stop talking over me? Is that part of your brain broken? Stop. Or I will hold you personally in contempt, and I will send you to go visit our brand new accommodations. You know, we don't charge you rent there. I hear it's beautiful. Oh, actually, I did tour it. It is pretty beautiful. Pretty beautiful jail. Okay? Stop talking over me. Stop. From January 1st, 2023 to January 1st, 2020, or no, to December 31st, 2023. You're swearing under oath that you did not rent more than 10 nights.
I can't make a comment on 2023. I'm not familiar with 2023. I'm talking about 2024.
And I'm talking about 2023
I
because
can't comment on 2023. I don't recall. I don't remember.
my injunction's from July of 2023.
But he's presenting
But
evidence.
my injunction's from July of 2023.
I understand it, but I can't comment on 2023.
Why not?
I don't recall. I'm just reacting to what evidence he
Okay,
presented.
then from January 1st, 2024
Mhm.
to January 1st, 2025, you're swearing under oath that you have, or to December 31st, 2024, you're swearing under oath that you have not rented more than 10 days. Under oath,
Well,
under oath.
it was, my intention was to rent
Mr.
10 days.
Olson, it's a yes or no question. From January 1st, 2024 to December 31st, 2024, have you rented your property more than 10 days? Yes or no? That's a yes or no. That's a yes or no. Yes or no? Yes or no?
I think the contract's
Yes
11.
or no is the answer. Yes or no is the answer.
To-
Yes or no is the answer.
I think.
Yes or no is the answer.
I don't understand.
Yes or no is the answer. Yes or no
What's
is
the
the
question?
answer.
What's the question?
From January 1st, 2024 to December 31st, 2024, did you rent your property for more than 10 days? Yes or no? That's your only choice, yes or no?
No.
You did not.
not
more than 10 days.
No.
From January 1st, 2024 to December 31st, 2024. You did
That's my
not
recollection.
rent your property for more than 10 days.
Yes.
You did not.
Yes, according to his,
I want to know, did you rent your property for more than 10 days during that time period?
it was just those two renters. No, those 10 days. Just those two renters that he put together.
I don't want to hear extra words, okay? No extra words. You've already said it, so, but I want to hear it again. No, 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 no. I want to hear it again. No, 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 no. I want to hear it again. From January 1st, 2024 to December 31st, 2024, did you rent your property for more than 10 days? Yes or no?
No,
No.
no.
All right. No.
So can I,
That's no.
okay,
That's all I needed. No. All right. So, Mr. Anderson, you wanted to make an argument off of his statements? If you want to, otherwise I'm moving on so we can briefly get this done.
You've already denied them, right?
Yes.
I'll make it later.
All right. Okay. So, Mr. Olsiams, it is now your opportunity to provide any testimony or any evidence if you wish to do so. Ms. Olsiams is staying. She's waiting to see if she wishes to after you present your case.
okay, I'm gonna take all my exhibit stuff up there, so I'm gonna basically kind of
Well, you
freestyle it.
can't look at documents when you testify. You can have an idea and go to the exhibit.
I know, I need to have it all in front of me, though. I'm gonna be making references to various exhibit. I mean, I can do it here, I can do it
Yeah,
there.
you're gonna do it at the witness stand, but yes, you can bring them up there. You can't look at them while you're testifying. If you know what document you're gonna go to, you can go and grab that document and then you can testify from that document.
Well, I'm gonna be doing a lot of going back and forth from the,
Your Honor, if it makes it faster,
Yeah,
I'm
just
okay
make
if
it-
he has his documents up there.
All right, okay. Well, that's what I meant. He could keep them up there. He
Okay.
just had to grab
I think
them.
he was misunderstanding.
yeah, I thought you had to. I had to
You
go
just
back
had
and
to
forth.
grab them. You can't sit there and look at them while you testify. You have to know which one you want and then grab them from the pile at the witness stand.
Okay,
Has he been sworn
Um,
today?
I-
Swear him in again.
Raise your right hand, please. You affirm that the testimony you're about to provide in this matter shall be the truth, the whole truth, and nothing but the truth?
yes. Okay, go to the-
Witness stand. All right, you may begin. And
Okay.
you are not represented. That means you have the ability to provide more of a narrative. It does not mean that you have the ability to go wackadoo. And then Mr. Anderson will be able to ask you questions. Ms. Olsiams will be able to ask you questions if she wishes as well.
Okay, I'm gonna just basically go off of Mr. Brimmercomb's affidavit as kind of a steering from what I'll talk about, but Mr. Brimmercomb is not truthful in his affidavit. I've never had 16 vehicles there. It's not even physically possible to park 16 vehicles there.
Objection, Your Honor, when he says there, what does there mean?
On my property and even the disputed property, it's not even possible.
I got it.
Okay, and that's where you were going, Mr. Anderson, because I was going to say to speed it up.
Yeah,
But
that's
now I
okay.
understand where you were going because we have been talking about their, meaning his property, as well as the Miller's property, as well as the Brimmercomb's property, as well as the Donahue's property. So now I completely understand your objection. So it's sustained, and now he has added an additional answer, I believe.
Yeah, thank you.
Yeah, so are we all clear on that? It's not only my property, but also any of the disputed property. Talk about the survey.
You can talk about all the
Okay,
things.
so this is exhibit number 2, and again, Mr. Brimmercomb was not truthful. The access easement, I'm part of the survey. In fact, if you will let me bring the video up, you can see, this is getting a little technical, but in the survey, you know what that that circle means? Each one of these empty circles? That's a marker that's in the ground. You see that? Where it says access easement and there's two hollow circles.
Okay, I'm gonna let you know how court works. Court doesn't work at you ask me questions and I answer questions to you. Court works as you provide me with testimony as to why you're not in contempt and why you don't have to pay damages. You don't ask me questions to see if I see things. You just give me testimony as to your document and what it means.
This is the survey of our properties, and these two hollow circles are monuments in the ground that you can see from the video taken last week are actually on the other side of the road. So when Mr. Brimacombe was not truthful in his testimony about this survey, the road is actually in between those two circles. It's called an access easement because when the property was sold to us, I was told that this, because there's so many trees around, that this open area is not Mr. Brimacombe's property. He keeps claiming that it is his property, but it's not. It's actually the road, and this open area is actually in this access easement. And that kind of makes sense because the road is right next to the lots, and the road is right next to what is lot 3 and lot 2, because obviously the Donahues have to get into their property. So if you want me to bring up the video, I can prove again that those two monuments are in the video, and you can see that they are on the other side of the road. So the road actually comes through the access, between the access easement and lot 2 is the road, which would continue down the side of lot 3.
And
That's where the road is.
Mr. Elsims, for the record, I'm going to get the little stick. And I'm going to have those, if you offer that into evidence. And then I will be able to look myself.
I offered the video, it's,
Can't offer it yet because you can offer it when you provide testimony. But then I would be able to look at it and watch it before I make a decision. So I don't need to watch the video again. I will be able to watch it as an exhibit.
well, what I'm testifying to is that the road, that's where the roadway is, that people access the property. And it makes sense, obviously, the road would have to be right next to the lot in order for me to access my property. And it has to be right next to lot 2, so Mr. Donahue can access his property. So the road is right there. So just jumping around a little bit, another point that Mr. Brimacombe was not truthful on was, let's take the infamous urinating picture. The picture is actually taken just outside of that easement, because the easement itself is open. So he's hanging the cameras on the trees, and the trees are just outside that access easement. So the camera is, I would say, approximately where that north 32 degrees 05 dash 0, that's where his cameras are. Can you see that? North of the access easement, N space 32 05 03 degrees. That's where his cameras are. So his cameras are, as that picture shows, the urinating picture, that's actually happening on that access easement, which is not Mr. Brimacombe's property. And Mr. Brimacombe knows that. He's been up there for 40 years. He knows exactly where that is. And the reason why he didn't want to say the truth is because he knows that the truth is that it's not his property. So again, back to this picture. I've introduced this. This is Defense Exhibit 2. This is a picture of my driveway. The camera is sitting on top of the garage, and it's looking down my driveway. And only in my driveway, you can only fit 5 vehicles. You can see that there are 5 vehicles in the picture. It's 1, 2, I'll count the trailer as a vehicle. That's 3, 4, and 5. And everybody, so again, if I can give the judge a little perspective. So this is the road. That's the road.
Your Honor, this is getting a little bit difficult.
It
He's
is
saying
because-
this, I'm not seeing what he's talking about.
And for the record, again, Mr. Olsiams, we need words because the court reporter is not able to take down when we say this or we point to something, because it has to be in words, and I do understand what you're trying to say. But that's what's making it difficult. When you're showing, I guess you need to show back so Mr. Anderson can see as well.
Okay. Well,
And use such descriptive language as north, south, east, west. The
well,
end of-
I'll call the top of the survey north. Is that fair?
Yes,
Southern part of the survey south. And then the right side, we'll call that east, and the left side west. Okay? So on the northwest side, the road is on the northwest side of lot 3. Northwest of, there's 2 dotted lines with an N at the center of it. The road is on the other side of that line. And then Defense Exhibit 2, that's where the road is, right here. Right there, and that's northwest on lot number 3.
by right there, you're pointing to exhibit number 2, the very top of the exhibit, what you can see as brown gravel or dirt.
Right, that's the main access road for everybody's property. Now, I have owned the property since 1996. And I have, on the north side of lot 3, I have parked my vehicles, snowmobile trailers, and have used that part of the property up until 3 years ago when they claimed that it was their property. I parked my vehicles there for 20 years. So this tree that Mr. Brimacombe claims was a chain was wrapped around it, that chain is on my property.
On the tree that Mr. Miller testified was his tree? That tree?
Yeah, that tree is actually inside of lot 3.
But that's the same tree that we're talking
It's
about?
this tree right here on the north part of the picture, right beyond the pontoon trailer
In
that's-
exhibit 2?
in Exhibit 2, yes. So that tree is actually on my property.
Exhibit 2 of, help me with that. I think we're getting,
Is that the survey or the picture?
I'm sorry, I'm getting confused. So exhibit 2, what's the testimony about the tree from exhibit 2?
He's indicating and stating, if you can look at that big silver vehicle, and next to the big silver vehicle, there is a tree.
Beyond the pontoon trailer. That's the infamous tree that Mr. Vermicombe says a chain was wrapped around.
Oh, now I'm confused. Is
Where's
it the one way back here or?
No,
is
no,
it-
no, right here, beyond the pontoon trail. That's the big tree that,
I don't
see the
even
pontoon
know.
trailer?
It's hard to tell.
This is the.
It's very hard to tell. He should probably circle it on,
This is the tree right here.
here. That doesn't help anybody because it certainly doesn't help me make a
Okay.
decision and it doesn't help the court reporter. So just circle
I've
what.
I've
big
circled
tree-
what is considered the big tree that Mr. Vermicombe claims a chain was wrapped around. And I'm claiming that's on my property.
And Mr. Miller claims that it's his property. Right? That's that same tree.
Yeah, yep. Because remember, that tree is on the south side of the road. Remember, there's the access road, which butts up against the lot. That's the whole point of having an access road. You typically put it right next to the lot. So if the tree is on this side of the road, that means it has to be on my property.
Why does it have to mean it's on your property?
Because the road abuts lot 3. So the tree is on this side of the road. That means the tree has to be on lot 3.
I don't understand this side of the road. I need to know.
The
on
south side of the south side, the tree is on the south side of the road, which means it's on lot 3, which is my property. So again, looking at this Defense Exhibit 2, which is the picture from my security camera, it's not physically possible to have 16 vehicles on the property. It's not even possible to have 10 vehicles, maybe 10 if you go down where the tree is, which again is my property. To the left of that, I've been using that part of my property for 20 some years. If you draw the comparison, I think you made a reference to these 2 exhibits, Your Honor.
What, you need to identify them on the record so that I can understand what they are, so the transcript can understand what they are,
Okay, so
so Mr. Anderson can understand what they are.
the plaintiff's exhibit number 7, okay? You can see that there is a big, large tree with a sign on it. Exhibit number 7 from the plaintiff.
From the last hearing, yes, okay.
If you want to see, I have it right here. Here's that big tree.
Yes, I'm looking at it right now. Exhibit number 7, there is a sign on it. I cannot tell if it says no parking, but it appears to be.
That's my sign. It says no trespassing because I'm saying no trespassing because it's my property. So that's what that sign says. So to make a correlation to connect the exhibits, this is the plaintiff exhibit 7. This big tree is the same tree I circled on exhibit 2. To give you reference. So that's how these 2 pictures are connected. So if you see that exhibit 2 from the defense only has 5 vehicles, that's these 2 vehicles, the white vehicle and the, looks like a blue vehicle to the right of the big tree, and plaintiff's exhibit 7. So assuming that there were 5 vehicles, which equals the white vehicle and the blue, there's only 4 other vehicles, of which I'm claiming that's my property. So to the left of the sign on the big tree, where those 3 vehicles are parked, that's my property.
There's a truck or
The red one, the red truck.
no, but next on exhibit 7, next to the white car, there looks like a Trailblazer or something like that. Some kind
Right, on
of
page
soccer
3.
mom vehicle.
Yeah, like page 3 is the end, the equivalent of defense exhibit number 2, the last 2 cars on the driveway. That's the connection to the plaintiff's exhibit. So do you see on page 3 of exhibit 7, there's a white car and a blue SUV. That's equivalent to the last 2 cars on my exhibit, defense exhibit 2. That's the connection. So even with the plaintiff's pictures, assuming that there are 5 total vehicles in the driveway, 6, 7, 8, there's 9 vehicles pictured here, assuming that there are 5 in the driveway. So again, it doesn't equal 10. It's not between 10 and 16. It's not physically possible to have that many cars parked on my property, or I think that's disputed. They think that that's part of their property. It's not possible to park that many cars there. Now, the reason Mr. Brimacombe was doing this is because I think that he has,
Speculation.
Sustained. You can't speculate as to why you believe he's doing something or not?
Well, it's clear he's embellishing his affidavit to make it look as bad as possible to try to justify some kind of injunction against a natural right to rent your property. Again, this is seasonal property of 365 days a year from June through August. That's a relevant 90 days. Mr. Brimagom talks about so many vehicles coming here and so many vehicles coming there. 75% of the time, there's absolutely nobody at this property or on this island or peninsula or whatever. So the frequency, Mr. Brimacombe wants to make it think that, you know, there's 5,000 cars coming and going all the time during the year. That's just simply not true. And again, I think what is going on here is they look at this island as their backyard and they don't want,
Speculation, Your Honor.
I'm telling you what I think my knowledge is.
You can't speculate as to what people think or may believe.
So back to the frequency, again, 3/4 of the year, there's nobody here. Of the relevant other 3 months, I don't know, I would say probably, again, whether somebody's renting there is irrelevant really for the traffic. There's nothing in the law that says I can't have 20 vehicles or 15 vehicles on my property if I so choose.
Read Burnett County local ordinances? Have you
I
read
haven't-
those?
I haven't come across anything that tells me I can't park my car on my property.
Guessing you haven't read their ordinances, which were attached to my decision, I believe.
Well, we're just talking about numbers then, right? I mean, so
Yep, keep asking.
either way, his affidavit's just by the picture is not true. And again, frequency, it's very infrequent. 3 months, it's only relevant 3 months of the year. 3/4 of the year, there's nobody there. Comment about the septic system. I'm a construction person. I'm in real estate. I have designed 6 septic systems for multi-million-dollar homes. I'm familiar with all of the issues, principles, necessities of a septic system and the purpose of it, what needs to be done for it. I haven't personally designed 6 septic systems. I have installed 6 septic systems. My septic system is in perfect working order. In fact, I've actually,
I'm all object. He's trying to testify and he's trying to make himself to be an expert, but I don't think that he is an expert. 6 in the course of a lifetime does not make you an expert.
All right,
well, it's relevant, Your Honor, because of,
It might be relevant, Your Honor,
he's
but it's not,
accusing,
it's not, he's not an expert.
Mr. Osiums, I'm going to allow you to testify as to this septic system, how you believe it's functioning, how you believe it's smelling or not smelling,
okay.
and how it's working. If you've ever had any problems with it.
Okay. So basically, again, like I said, 3/4 of the year, the property sits idle. Okay. So what a septic system, it's designed in Wisconsin, it's based on the number of bedrooms. And typically what you really want to care about is not a weekend where there's 25 people there. What you want, because the system's designed to take on an occasional overage. That's its purpose, because everybody knows that occasionally there's going to be a wedding or some kind of party or people getting together. There could be 30 people there. There could be 50 people there. The real issue is what's happening day after day, week after week. That's what stresses out a septic system. And that has not happened with my septic system whatsoever. I have actually over-designed it. In fact, I have spoken to the county zoning people about my design. I've actually added a special tank at the end of the septic system to make sure that it does not fail, to keep the solids out of the septic system. I don't know if your honor knows some basics about how a septic system works, but
I certainly do. I've had to have them installed in the multiple properties.
so you know that the basic design is one tank, but the problem with that is solids still go through the first tank and then end up into the leach field, the drain field. So what you want to do is you want to add separate tanks, so it leaves the first tank, then it goes into the second tank, and a lot more solids drop out. And then the solids don't end up in your leach field. So the original design from Burnett County was one tank. I actually added a separate second tank to come out of the first septic tank to make sure that the solids don't go into the drain field. And, you know, that's what destroys a septic system and causes a quote unquote poopy smell, which another reason why the plaintiffs are not truthful in smelling something, because in order for something to smell, there has to be a puddling, because ultimately, if something's wrong with the system, it's going to end up in the drain field. There's going to be puddling. You're going to have backups in the house. That certainly has never, ever happened in my house. So just saying that I smell a poopy smell is kind of like a layman going into the hospital saying, I see blood on the floor. I don't know where it's from. I don't know what this is, who's causing this. But what I can say is it was over-designed by me. I've designed and built 6 myself. This system is overbuilt, over-designed, and is in perfect working order. And again, I think what they're trying to do is come up with every single little thing they can think of to justify a nuisance.
Same objection, Your Honor. He's speculating.
Sustained.
So again, the septic system is in perfect working order. So Mr. Brimacombe's comment, paragraph 8 about not designed to accommodate that many people. Again, it's not a temporary one weekend or 1 week thing where there's going to be 25 people. What we're talking about is, are there 25 people every single day of every single week of every single month of the year? And if the system wasn't designed for that, then that's another matter. But again, because 3/4 of the time there's nobody there, and the systems are designed to take that temporary 15 people, 20 people. Think about it. If they didn't, then nobody would ever be able to party, nobody would be able to have a special event. The system is designed for a temporary, occasional, more people than what's designed for it. Mr. Brimacombe says in number 9, defendants put their items of personal property on the plaintiff's real estate. So again, we're getting kind of nitty gritty, but it really comes down to what this survey says, because ultimately, Mr. Brimacombe is claiming property that is his, that is not his. And specifically, this access easement up until about 3 or 4 years ago, when his dad was still alive, his dad would complain also that I was parking cars on his property.
Your Honor, I'm going to object at this point for 2 reasons. Number 1, this is a damages and contempt hearing. The court has already found trespass. The court has already found damage. The issue is not, did the damage occur? Did a trespass occur? The issue for today is simply, did Mr. Alciums and or Mrs. Alciums engage in contempt of court? And the second part is, what are the damages for the actions that have already been found by the court? And so to go down this path of trespass and whether there was or wasn't, we've already established that.
Well, what's important though is where he's claiming the trespass was. So again, it really comes down, the details do matter. What is specifically his property or not.
And I'm going to say, I do agree with Mr. Olsiums to a point, because it does matter for some of these issues of damage, because I have to assess multiple different
True.
types of damages that are alleged. Urinating is only one of the alleged damages. So it is accurate that with regards to the testimony, that's some of the testimony is actually needed and necessary.
Fair enough. Thank you, Your Honor.
So basically, everything he's claiming is his property is not. And again, that's a linchpin to a big part of this. It's a big linchpin to his less than truthful affidavit. The details do matter. What is his property and what is not? And again, what he's claiming is his property is my property. In fact, Mr. Brimacombe's property is way, if I was to reference this survey, his property is way to the northwest.
Mr. Olsiams, I want to stop you again, just to remind you that this isn't Mr. Brimacombe against Mr. Olsiams. There's multiple other plaintiffs as well. So it's not just Mr. Brimacombe against Mr. and Mrs. Olsiams.
But Mr. Brimacombe's the only one that testified about property on his property. I think the
not.
Millers did too. Well, the Millers, they're on the other side here. And what happened is I was using this property for 26 years. And then 3 years ago, they claimed that the property I was using for 26 years is actually theirs. So again, I'm claiming that what they're claiming is their property is my property, and I've been using it for 26 years.
And I would object to that then too, Your Honor, because the adverse possession claim has been dismissed.
I'm not talking about the adverse possession claim. I'm saying that what is my property.
He
'Cause
does
again-
not- Yes, he does not believe he adversely possessed it. He believes that he physically owns it. So we don't need to go down that aisle.
Just for reference, Your Honor, the Miller's property is north of the lot 3 line. You see where it says in big letters, lot 1 CSM V13, pages 244 to 245 on the very top. That's the Miller property. So real quick reference to Exhibit 7. I'm claiming that these cars next to the big tree is my property.
And so I can be clear,
And there's the road.
and I can understand the cars parked in Exhibit 7 are across the road from your property.
No, they're on the other side. They're on this side of the survey. They're on lot 3.
They're on the same side as your,
Yes, on lot 3. Because remember, here's the reference. There's the road right here. You can see the road in the picture.
all right.
So to the left is my property. So you're coming down, if I'm going on the survey, you're coming down the road, my property's on the left. And here's the big tree on this side of the road.
Again, I can't, it's hard for me to see, it's hard for Mr. Anderson to see, and the court reporter can't really take.
Can I just write on the exhibit where I say the road is?
You can do whatever you want on that document. That's your document. And then if we use it as a secondary exhibit, you can offer that if you wish. Because I don't believe he even offered Exhibit 2. I don't believe I've received it.
The survey?
Yes, I don't believe I've received any exhibits from you. I may have physically have them in my hand, but I don't believe you've offered them, and I don't believe.
Well, these are the two exhibits I've offered, are the survey and the picture.
Are you asking the court?
I'd like to record to receive these 2 exhibits.
I will receive them.
So I've written on my exhibit where I say the road is. Can I show Your Honor where the road is?
Why don't you draw with a purple marker? Oh, no, I have a purple marker.
Okay. On my exhibit or yours?
Yours. Because yours is going to be the pretty one that you're going to offer as your own exhibit. And mark down any
So
other things that you think is important, like the big tree. Like any other things that you think is important for the court to know. Any other thing that you think that is important for the court to know.
Yeah, I'm calling the big tree is the tree that they said that the chain was wrapped around.
Well, I want to make a plaque and put it right on that tree and call it big
You know,
tree.
it'd really help if you were to go out there and look at it, but obviously it's not possible. But anyway, I've marked on there what. So you see how that matches up with their exhibit 7. You can see the tire tracks on the road. So I think that helps to clarify.
Are you gonna have that marked as an exhibit?
Yes, can I?
Yes.
Number 3
No,
is a separate one.
Where are we?
We're on 5.
We're on 5. So you can keep it and we'll
Okay.
know.
I'll just write exhibit 5 on it.
No, yeah, just in the bottom corner, just write a little 5 and then we'll
Okay.
take care of putting on the exhibit sticker.
Okay, so I wrote 5 on there.
I'm sorry, Your Honor, 5 was on the marked up.
Yes.
Yeah,
survey.
yep.
And he is offering it and the court is receiving.
So basically, I'm trying to give the court a picture out here of what it is. It's not possible to have 16 cars out there. There's huge trees everywhere. This big tree. You can see the road goes off to the left. There's a swamp. That's where the high water line. You can see a swamp there. Well, I never to be honest, I tried to not create conflict with Mr. Brimacombe. I've never tried to purposely park anything on his property. Just try not to inflate the situation. I think a big part of this, again, I'm referring to exhibit 5. You can see to the northwest of the purple road called the access easement. Remember, I asked Mr. Brimacombe if that's where he put the no parking signs. So what Mr. Brimacombe was doing is he erroneously assumed that that was his property because Mr. Brimacombe's property is on the other side of the access easement. So before all this got started, I don't think he looked at the actual survey and didn't realize that that opening, that access easement was left opening specifically for when I bought the property because I need that opening to be able to turn into my property. And when I bought the property, the people that were selling it, they went and specifically plotted that little access easement specifically for me to be able to get in my property. And over the last few years, Mr. Brimacombe did not realize that, and he started to park cars there on purpose, claiming it was his property, not realizing that it was an access easement that was to remain open and not to be parked on. And he thought it was his property where he could park cars there. So I think a lot of the comments from Mr. Brimacombe about parking stuff on his property is this access easement. Because again, he's not on the Millers are on the north side and the Donahues are on the southwest side. So I don't even abut Mr. Brimacombe's property. So he erroneously thought that that access easement was his, but it wasn't. It was, as you can see, it was specifically plotted so that I have an open area to get in and out of my property. I think he was saying that's where the majority of what his claims were, that I was parking stuff on his property was this access easement.
And is the access easement, if we look at exhibit 7 on the other side from the parked vehicles?
No, because you're looking at it, the road curves to the right. So I'm gonna go to number 2, the access easement is over here where this car is parked. That's the access easement. So if you can kind of look at the survey, you see where the road is. Now here is the Donahue's property over here. So you can see just across that is the access easement. And again, Mr. Rimacombe thought it was his.
You can see a vehicle's parked on that access easement.
Right.
I can't see whose vehicle it is.
I don't know whose it is. It could have been his, because when we got close to
This is me, right?
the last few years of this, he was parking vehicles there just to spite or just to block and just to interfere with the use of that area of the property because he thought it was his. But in reality, it's an access easement, so it's not his property. I think this general concept of him thinking that it's his property and is not.
Objection, Your Honor, as to the, again, I've let him go quite a bit on speculation here, and I'm gonna enter objection now.
It's sustained.
That access easement's not his property, and he's claimed in his testimony that that was his property, and that's the source of a lot of this trespass and a lot of this real putting my stuff on his property is that access easement. And again, I don't have any property that abuts his. So why would I want to or need to park anything on his property? It's away from my lot. I'm just trying to explain the confusion. But the, again, the survey shows exactly what that access easement is for. It's not his property. Okay, number 12, defendants remove foliage from trees from plaintiff's real property. Again, I think, I don't know if you remember, Your Honor, when the water was really, really high 3 or 4 years ago. Well, what happened was it was so high on this lake that it actually covered the roots of big oak trees. So the water level came up so high that it killed the trees. So from the point, the high water mark, it went past that. It was probably a 500-year watermark, and it killed the trees. And what I did was I just simply cut trees down that were in the, basically where it says against lot 3, Birch Island Lake. And if you're to rotate around again where the Miller's property is, you can see where it says high water line on the north side of the survey. Those trees were below the 100-year high water line, and they all died. So I cut those trees down that were in the high water line so they don't rot and fall on my property. And sure enough, what happened is one of the trees that did die fell on my snowmobile trailer and destroyed the trailer this past summer because the tree was rotten. It had died and fell on my snowmobile trailer. So I didn't cut any trees down that were above the high water line. It's simply below all the trees that were rotten that needed to come down just for safety reasons. I think that's what he's commenting too on 13. Defendants have removed timber from plaintiff's real property. Yes, the trees I did cut down in the high water mark, which technically is not his property. I guess that would be the state's property, right? Below the high water mark. And I believe you're able to cut down dead and diseased trees. So that timber was not on his property. It was below the high water mark.